Board of Adjustment for Weaver County. First item was Pledge of Allegiance. Please stand and pledge allegiance with us, please. Okay, like we've got a full quorum here, so we'll go ahead and move on to our minutes. For the meeting on September 16th. Has everyone read those, and anybody have any corrections or changes that need to be made?
Chair, I would move to approve the minutes. And second.
All in favor, say aye. Aye. So, stand approved. Our next item is BOA 2021-10, consideration of appeal of the planning division decision to deny a land use permit based on the county string corridor setback requirements. Applicant is Scott Bracken. Are you here, Scott? Or do we hear from staff first?
On this one, you may want to hear from staff, and then if you have questions for the applicant.
Hello, board members. I think you all know me, but for those who are here who don't, I'm Steve Burton, from planning. And what I'll do is just, I think this would be helpful if I went over the what the Board of Adjustment, what the ordinance, what the land use code says when determining appeals.
letter and our concerns with regard to the situation, because the term year-round is not defined in county ordinance. But I think we all know, have an understanding of what year-round would mean. And the Bible, I mean, the dictionary talks about year-round being something that happens or continues throughout the year. Well, this is an artificial water course where water is not included in that channel for an entire year. And in fact, D. Staples, who was the director of the irrigation company, indicates that this channel was dug many years ago as a way to convey water from the stream, not being the stream itself, but convey water from the stream to a reservoir. And so this is not a year-round stream. This is an artificial water course. It's a diversion channel which passes near the Bracken lot to the collection reservoir, and therefore it is not the stream as defined by the code. Yes, for whatever reason, there's a map that the engineers put together that we have the authority to be able to review the facts that we provided to you from the irrigation company, indicating that this is not a stream, but in fact an irrigation facility. And based upon that, this board, this body has the authority to make the interpretation that the stream ordinance does not apply. The staff is more bounded by the ordinances. You have the responsibility of interpreting those ordinances, and this is a situation where year-round is not defined, that the 75-foot situation is very impractical for this particular lot. The variance decision is separate from the decision that we're asking the board to make today. That decision is separate, and that's something that we can deal with at a separate time. But there is not water in this subject channel year-round because according to the director of the Wolf Creek Irrigation Company, Wolf Creek Irrigation Company does not even have the right to use this channel next to the Bracken property from November 1st to February 28th. And so water cannot flow to it during that time period, so therefore it cannot be year-round.
Mr. Hammond, I'm looking at this page
Yes.
where they've got a rough diagram of this year-round stream. It seems to be more of a diversion for irrigation water than anything else. Where would that? Is there a year-round stream nearby?
From what the irrigation company explains to me, it is nearby, but this area, I don't know exactly where it is because it wouldn't be on this map. But this is a diversion area, not like the actual stream.
If the diversion that we're talking about, and the actual stream is not on the map, why would the county think that it's on the map? There's something on the map. They're calling a diversion canal a stream. That's the contention here, correct?
Yes, I don't see the engineer here to support that conclusion.
And what about D. Staples? Is that the gentleman's name you said from the
Yes.
water company? Is he here to testify?
He is not, but his information is in the record.
Did I probably read it and I apologize. I don't remember reading it.
Well, it's in my letter. It's in my letter that I spoke with him. Mr. Bracken spoke with him. This is the information that he gave us.
But there's nothing nothing from him directly,
There's not like an affidavit from him.
even a letter.
It's just you saying that he said that. Is that right?
You know, doubt your integrity. So, that's all the questions.
Any other questions? Did you have anything else to add?
Mr. Hammond, just a quick question for you, because you're the one that corresponded with the irrigation district official. Is he, I know his water right has a particular season, but is he saying that, now that would be a diversion water right, but is he saying that there's no water that flows in the wintertime? Can you state that?
He says that there's no water that flows. He does not have the right to use that water through the channel next to the Bracken property from November 1st through February.
And I read that, but that doesn't say that there's no water
Yeah,
flowing
it
during
doesn't.
that time. And that's why I wanted that clarification.
Well, that's what I understood it to mean, but certainly I understand your distinction.
And, you know, if there's water upstream, it has to go somewhere. It goes downstream. If it's a year-round stream, it flows downhill. If he only has a diversion right for this period of time, that water would continue to flow during the winter months. And unless we have some document that shows that that stream corridor is somewhere else, that we have to go off of what the county record shows as the year-round stream.
If it's cut off, that's exactly right. If it's cut off and it can't be used, that's one thing.
But they just can't use it for irrigation, but it still might have water in it.
Right. So what I'm saying is if there's some kind of a canal mechanism that stops water from flowing, and I'd sure love to heard from.
And perhaps an alternative would be to table this and bring Mr. Staples in. Do you have any questions for me or for Mr. Bracken?
Just for my benefit, Mr. Hammond, how far off are we on this picture? This
About
diagram?
55 feet instead of 75. Is that the question that you're asking? 55 feet?
We're 20 feet short.
Yes.
Thank you.
You have any questions for me or for Mr. Bracken?
I do. Yeah, I want to open up to the, oh, yeah, let's have the, Mr. Bracken. Yeah,
Hi. Fun, isn't it?
No.
I'm trying to make this as painless as possible for you, sir. So how much feet do you need?
Well,
So you don't want it named as 75.
no,
And so you 50?
because the unusual shape of the lot,
Mhm.
number one, and the setbacks.
Mhm.
When I purchased the lot, it does show in county records that I'm supposed to be 50 feet from the high water line. And so everything was planned around.
Can
that.
you repeat that again? When you
The-
purchased the lot?
Yeah, so the county records indicate that I needed to be 50 feet. from the creek.
Okay,
But when I went for my building permit, they then told me there was a hidden ordinance that I never found during the process of purchasing, so I need to be 75.
okay, so you looked it up yourself in the beginning
Correct.
and, okay, and so
Correct.
you wasn't necessarily hidden, you just, which code feels like it can be hidden.
Nothing recorded against my property indicated I need to be 75 feet from the creek.
Okay. So, and I'm not asking this to criticize or to say that you can't build a house, but is your house about standard size according to the other houses in your neighborhood?
Yes. It's
You're not
pretty
trying to build a
standard. It's
castle?
2,200 square feet,
And that's,
not very big.
no. That's it?
That's it.
Okay, thank you.
Is there something else I could bring up?
Ask the chair.
I'm not sure it was really clarified on when the water runs and when it does not. It's been dry since March 1st. I mean, yeah, March 1st up until the 1st of this month. And it shut off during that time typically. It was shut off a little earlier this year than it typically is in other years, better water years. But
so is
it's
there a
shut- it's
physical
totally
barrier
dry,
to shut?
totally diverted several months out of the year, if that helps.
That's what I was gonna ask.
Is there a physical barrier that shuts it off?
Yeah, oh, yeah, they divert it up higher up the canyon, divert it off a different direction, totally dry.
Okay.
Any other questions on Mr. Bracken? Do you have anything else to add?
I have a question, sorry. So they shut it off past your property between approximately March and November, between November and March. Is there water running through it?
There's water running through it. presently.
Any other questions? Do you have anything else to add?
Yes, I know that when the Weber County approved this subdivision, they approved it in 2003. The ordinance supposedly went into effect and is recorded in 2005. Since that time, 3 other homes, the one next door was built last year, was given a 50-foot variance. The 2 homes behind me were also all my neighbors on the last lot in the subdivision. It's now being required to have 75 versus 50. So these other properties were given variances. Two 2005, 2014, 2020.
Okay, do we have a staff comment about that?
I'm just curious, because I asked you about the grandfathering, and yet, is that accurate?
The staff comment about what?
The fact that he just said that in 2003, he bought the lot. In 2000, okay, would you repeat your?
Subdivided.
Oh, okay.
Subdividing.
But the property was subdivided in 2003.
That's correct.
The ordinance adopted 2005. That's
Yes.
what you're saying.
Mhm. It would be similar to this is essentially an overlay zone. So
Mhm.
just like zones can affect property and change what's allowed on that property, it's the same thing. This overlay zone impacts the property in a different way than it did in 2003.
And staff, can you verify that the houses on the same street all got the 50-foot setback?
I can't verify that what type of a variance they got. We probably could look it up. I don't know really how relevant it is if we're just considering the land use permit, but we probably could look up in just a few minutes what those variances were approved for.
So property next door is my brother's, and he's 50 feet away.
Can't let your brother win, huh?
Yeah.
Okay, is there anybody in the public, either on Zoom or in the room, that would like to talk on this thing? If you're on Zoom, use the raise your hand feature and
Chair,
I
this
don't know,
is
you
this
see.
is Brandon Green. Sorry to interject. For an appeal, there are only certain parties that can actually speak to this, and those are the ones that have been adversely affected.
all right, never mind on that. So we can take this under advisement. And on the closed session, if we desire, we can table it and ask for more information. Or is that basically our option?
I would suggest that we adjourn to the conference room and then we can discuss this and then we can.
We want to do that after our other items.
No, you'd want to do it while you have this agenda. item.
So we adjourn to the conference room. And then we would just offer a written. We don't have to make a decision at this time. We can just offer a written decision at a later date.
So yeah, so at this point, the board can make a motion, or someone from the board, to close the meeting. The reason for your quasi judicial function to deliberate. We would hold the closed session and then come back in and motion to reopen the meeting. And then the board can either make a decision today, or if the parties agree, and this has happened before, the board can take it under advisement and issue a written decision later on. Usually that gives the board an opportunity to put out a little more well thought decision instead of something over the bench. Well, from there, let me know if you have any other questions.
Is there a motion to adjourn? Close.
So moved, move to adjourn. Second.
In favor, say aye. Thank you. Okay, first of all, we need a motion to reopen the meeting. And
So
I'll make the motion to reopen the meeting.
second it.
all in favor, say aye.
Aye.
Okay.
Will the chair accept it?
Yeah, is there a motion? Okay.
Chair, I'll make the motion that we deny the appeal, affirming that county staff did not err in their decision. We accept the engineering map as this is a year-round stream according to the county. That's my motion.
I will second that motion.
All in favor, say, oh, is there any discussion on the motion? All in favor, say aye.
Aye.
Any opposed? Okay, thank you.
And Chair, if you would do a roll call with that motion, just so we have on the record which votes were collected.
I do that.
Well, you could do it, or our secretary who's taking the minutes can call the names.
Would you like me to do that? Would you like me to?
Would you like to do that too?
I'd be happy
Thank you.
to. I'm sorry, I don't have last names. Rex,
Rex Mumford, yes.
thank you. Bryce,
Rice Floor, yes.
Jeanette. Is it Jeanette
I'm Jeanette Borkland. Yes.
and Laura Burton?
Yes.
Thank you. Okay, we'll move on to our next item on the agenda. Is number 3 BOA 2020-04, consideration and action on a request for a 15-foot variance from the rear yard setback in the FR-1 zone. Applicant Doug Neilson, staff Scott Perkes.
Thank you, Board Member Portland. Board members, just to bring this back into your recollection, this particular item we've seen a time or two. Most recently, we had intended to hear this during our meeting earlier in October, but our applicant had a happy surprise, and his wife went into labor that day, so we decided to defer that until today's meeting. So we'll forgive him for that. But our applicant is here if you have questions for him. I'd like to just share quickly the screen here so we can be on the same page as to the updated request. There we go. Okay, so this request actually first came before you, sorry, back in the summer of 2020. The applicant at the time had picked up the property and had multiple lots of record, subdivided lots from the early 1900s that were created in the canyon. And his intention was to redevelop these lots into a cleaner configuration where the structures could be separated a little bit better than the existing dilapidated structures were. And so at that time, to help facilitate the separation and the setbacks of these new structures, there was a request for a setback of 11 feet. So a 19-foot variance at the time was proposed from the rear setback. And then there's also a side yard setback that was requested, a variance to the side yard setback that was requested. That variance request was granted. However, the applicant, in going through the subdivision process, was required to actually subdivide this as a single lot to accommodate septic requirements through the health department. The health department now requires that we have a minimum of one 20,000 square foot lot as a minimum lot size for a lot that could accommodate a modern septic system. Given the size constraints in the canyon, these smaller lots of record would have to be platted as a single lot to accommodate a single septic system. And so the applicant complied with the health department and platted a single lot subdivision rather than a smaller 3-lot subdivision. And as such, that variance request that was previously approved in the summer last year became void. And so the applicant was asked to resubmit a new variance request to accommodate a new site plan on this single lot subdivision, of which he did submit, requesting the same rear yard setback. And so when we brought that to you a few months ago, the question arose, is there any more room on this single lot, now that it's a single lot, to get a little bit more of a rear setback, considering all the variables at play, including the septic permit requirements to the health department for siting that system on the property, but also accommodating the home. The applicant took that request of the board, went to a septic designer, and looked to see if there was any more room that could be found on the property to give a slightly larger rear yard setback. And so we have received an updated plan, which has frozen on my computer conveniently. There we go. So this updated site plan shows the septic system, its replacement field in the front yard, as well as some of the setback requirements that the health department requires. All of these variables considered, we were able to find another 4 feet in that rear yard. So the updated request that has been resubmitted is a 15-yard rear yard setback, which equates to a 15-foot variance from the 30-foot required setback in the zone. So that's a mouthful, but what we're looking at is a 15-foot variance for a 15-foot setback. Okay, so that exercise that was done at your request has allowed for a little bit more room to be found, and that is the updated request on this variance. Do you guys have any questions about how we've gotten to this point?
Questions of staff? Go ahead.
Extraction of the test.
That's yeah, the staff analysis, right? And stuff. Mhm.
Any other questions of staff?
One of the questions I had, sorry, was whether or not the US Forest Service has a problem with putting a house this close to the river.
That's a question we haven't been able to get an answer through the Forest Service on. Presumably, there are many structures in the canyon that are quite close to the river. I'm sure they're not happy about that. Those are the constraints of the canyon, unfortunately.
Scott, question for you that I've wondered in the past when this came up before. Is the property line, the north property line, or I guess it's kind of north, the angle, is that the river bank, or is that the Forest Service's boundary of the river? And if it is, how far away is that from that river bank?
That's a good question. We did look into the legal description of the lot, and the surveyor did not indicate that that property line was that river bank. There is a meets and bounds description, but it does not use that as a description. I'd have to lean on our applicant to maybe shed some light on that.
Any other questions? I do have one. Isn't this for a 15-foot variance or a 15-foot setback?
Both.
Oh,
So
So
there's,
the required setback's 30 feet.
that's right.
Okay. Oh, and did the health department review the plan in terms of the septic tank placement?
They did, and that's part of the reason why it took as much time as it has to get to this point, because the health department is looking at how many bedrooms are in the home. That then affects the size of the septic system, which then affects the placement of the home and septic system with regards to the setbacks. A lot of variables went into getting to this particular site design and plan and trying to whittle as much room out of this constricted site as we could, but this is where we've arrived after considering those variables.
So this placement of the home is accepted by them then? What were you
So
saying?
the health department isn't as worried about the placement of the home as they are worried about the placement of the septic system. So the septic system has certain setback requirements from lot lines and setback
Right.
from the home
But the
foundation
placement of
itself.
the home has to leave space for that.
That's right.
So if, if the home has to move because of the septic system placement, and we approve a variance for that, is that gonna,
Is that going to give them heartburn? Is that the question?
so do we know the exact distance from the back wall of the home to the river itself?
That-
Would be
We know that the
15 feet?
distance from that rearmost corner is 15 from the rear property line. This goes back to board member Mumford's question of, is there any more room between the rear property line and the actual river bank itself? And that's a question that maybe your applicant can answer for us.
Any other questions of staff?
So Scott, the drawing that you've got on the screen right now
Mhm.
is acceptable to the health department, correct?
I would assume yes.
I mean, it looks like it's fine. And this is the applicant's drawing, is that right?
This is the septic designer's drawing. So the septic designer drew this for the applicant. This drawing will be provided to the health department for the actual septic permit. But the health department wanted a drawing like this before they would even sign the subdivision plat, which they have done, and that plat is recorded. So they know that it is feasible for a septic system.
So at this point, we're just being asked to consider a 15-foot variance, basically.
That's right.
Thank you.
Mhm.
The applicant like to speak? Congratulations on your new baby.
Hello, thank you. Yeah, she's great most of the time. So, well, thanks for your time. A few items I would maybe provide that would maybe help in a decision. The home itself is just over 2,000 square feet footprint. That's excluding the garage. We, since the last time we met and we tabled the item until now, the change that was made in order to get the setback further from the river, the 4 feet from the river, was a 35-foot lateral change to the east on that east property line. So we had it there originally placed so we could have some more yard for our family on the east side of that property, is why we were looking for that. And so we brought it 35 feet to the east to crunch down on that space and thus come further away from the river. The septic system, and maybe it doesn't look like much to you, and it wouldn't have to me either, except now that I've gone through it so much with the septic design. The drain field has to be 5 feet away from that property line and from the home, and also has to give place for the tanks. Also in consideration for access is for the purpose of where he's put the drain fields. The primary and the I'm not sure the term, the fallback, the backup. Let's see here. So that's where how we got to this point. I don't think I have any other thoughts. Any questions for me?
I have one, Doug, perhaps, or Mr. Neilson, perhaps you can address the rear property line in relationship to the river as you know it.
Yeah, so this is just me talking. It's not on paper from the engineer or the surveyor, but Gardner Engineering is who's done our work here. And we know the front east corner, we know that spot. And so from that spot measuring back, and I don't have this in front of me right now, but we measured the exact distance from that spot. And it appears that the river is beyond that property line. So our property line, this claw shape, is not exactly on the river or beyond. This is
inside.
inside
the
of our
river.
property, yeah, onto dry land, especially as you go further to the west towards the garage. Yeah, so it appears to kind of curve more so than what the river does, if that makes sense.
Any other questions?
I just have a general comment for the applicant. Having driven the canyon for years, I think you've done a wonderful job of cleaning up the canyon. That was an eyesore
Thank
where
you.
you have scraped that off. And maybe it was to your own detriment because you lost your grandfathering ability had you just added on to one of those old shacks.
Thank you for bringing that up.
So
It's so true. It's been painful going through the process, especially with the health department. So in all reality, in my foolishness, I did the cleanup, truly. Because if we didn't do the cleanup, we would have at least 2 homes here that we could build on with the grandfather status. However, moving forward, now we have a nicer laying property and it is appealing that way, which is an improvement, which is nice. But boy, losing a tax ID number there also hurt, So, but it will be a beautiful property. It's really nice. Also, I would add the gal to our east and people across the river from us have thanked us many times. I can't tell you how many people have been arrested that have been doing unmentionables on the property and doing damage to the area. So it's really nice to have it cleaned up and taken care of.
So, and nothing to do with our variance, but I noticed between the last and this meeting tonight, but it's gone. There was a for sale sign up front.
You're right. Yeah. So my father's a real estate agent. He listed it for me for sale because I came to the conclusion after a few years of working on this, man, if it sells over the winter time, it will sell. If not, I'll build in the spring. We had multiple offers, full asking price cash offers. And we went under contract once and I had a change of heart while I was under contract and it was too late. They backed out. We had more offers come in and I took it off the market. We want to move into it. So.
Okay, so you're proceeding with what you've designed here.
Mhm.
Thank you. Thanks, Chair.
Any other question?
I just have a comment. It's a casual comment, so I apologize, but I'm sitting here thinking about all these questions about how close to the river you are. And if that dam broke, it just wouldn't matter. I mean, come on.
You'd be goners either way. Yeah.
It's amazing that you ever, seriously. Okay, good. I'm ready.
Any
Close
other
to the river,
questions?
close to the road, they're both there.
Oh man, it makes for a difficult lot, but it sure is pretty if we can manage to do nice on landscaping.
Okay.
Chair, I'd like to make a motion that
Want to hear if there's any public comment? Anyone else here to comment on this property? I'm not seeing none. We're ready for motion.
okay, I'd make a motion that to approve Board of Adjustment 2020-04 for a 15-foot variance from the rear setback in the FR1 zone.
I'll second that motion.
Identify the findings that it
Go to the second.
But certainly,
Staff analysis.
Yeah. yeah, that's what I was going to say. Letter A on the staff analysis, the literal enforcement of land use code would require an undesirable result. Hence, motion.
Yeah, if you'd like to adopt staff's findings, that is fine.
That's what I would do. Just staff's findings. Thank you, Brandon.
have a second.
I second the motion.
By Commissioner, right? For all in favor, say aye.
Aye.
That passes unanimously.
Thank you, board members.
We will move on to item number 4, BOA 2021-11, consideration of an appeal of several permits issued by Weber County, including Weber County Stormwater Construction Activity Permit, Building Permit number 21U388, and Land Use Permit LUP 232-2021. Applicant is Angelika, Spaey. Staff presenter Steve Burton.
Chair, I need to make a request to recuse myself as the applicant's counsel is an attorney in the law firm that I work in. I will excuse myself. I
Thank you
wish
for
you
coming.
pleasure.
Good evening, members of the board. My name is Cortland Erickson. I'm a deputy county attorney here. And before we get to the substance, the county would like to make a motion to dismiss this appeal for lack of subject matter jurisdiction. And there are a couple of reasons for that. Ms. Spaey appealed 3 different permits issued to a neighboring property owner, Heidi Christiansen, a building permit, a stormwater construction activity permit, and a land use permit. Of those 3, only the land use permit is a type of decision that would be appealed to the Board of Adjustment. The Weber County Code contains different chapters and different appeal mechanisms. Specifically, Chapter 12-2 of the County Code is the one that establishes the appeal mechanism for a decision of the county building official, and that would include a building permit. County Code Chapter 2-10 establishes an administrative appeal process for any decisions other than land use decisions or decisions of the county building official coming from the community development department, which would include the stormwater construction activity permit. So those 2 appeals we assert should be dismissed because they are not properly before the board, because they're not the type of appeal that the board has the authority under the ordinance to hear. As to the land use permit, the county asserts that it must be upheld, or should I say the appeal must be dismissed because the appeal was untimely. The facts show that the land use permit was issued on July 14th, 2021. The appeal is governed by Weber County Code 102-3-4A4, which says all appeals to the Board of Adjustment shall be filed with the Planning Division not more than 15 calendar days after the date of the written decision of the Land Use Authority. The appeal here was filed on August 26th, which was more than 40 days after the written decision was issued. And so for those reasons, the county asserts that it was untimely. It is expected that the appellant will probably have arguments, potentially that the appeal date was extended or the time didn't start running until some later date and that it was timely, and the county would respectfully request time to rebut those arguments if those arguments are made. And additionally, if the board does end up deciding to deny this motion to dismiss, then staff would request the opportunity to discuss the merits of the appeal itself, to talk about the record and to go over that and the underlying decision that was made. But for now, we believe that this is straightforward and should be dismissed because of lack of jurisdiction over the 2 appeals that don't belong in front of the Board of Adjustment and lack of timeliness of the appeal that would belong in front of the Board of Adjustment. Thank you.
So let me ask you just one question first. So what you're saying is that because that we're not, we're just looking at land use permit, not a building permit.
That is our position, correct?
And the timing of the appeal has to be within 15 days of that land use permit. That's what the ordinance reads. for
Yes, that is our
an appeal.
position.
Now, if it were to be the building permit, would that wouldn't go to this body, would just be, would be court? Or how?
Section, I'm sorry, chapter 12-2 of the Weber County Code establishes a Board of Appeals, and section 12-2-3 says any person adversely affected by any decision of the county building official must petition the Board of Appeals, which again is established under that county code chapter, which is totally separate from the Board of
So the Board of
Adjustment.
Appeals is a different body, it's not us.
Correct.
Okay, thank you. Do you have another question?
Thank you. And as I read through, I came to the same conclusions that you were citing here. But on procedure, I do not understand what we as a board are supposed to do. You're asking us to dismiss. And you've made a motion to dismiss? Can you make a motion to dismiss?
That is our position, is that we
So-
have the right to ask the board to dismiss this.
Okay.
And let me clarify here. I am here tonight in the capacity of an attorney representing the Weber County Planning Division, which made the decision on the land use permit. And so that decision got appealed that the Planning Division made. And so I'm here to represent the Planning Division in trying to get its decision, the appeal of its decision dismissed.
So this was so egregious, basically, and so that we're not even addressing it with the planning staff. You are going over the staff report. You are going over that because it's legal.
I'm here for the motion to dismiss. And
Okay.
if questions arise later about the staff report, then Mr. Burton would be primarily addressing those, and I may assist him upon request or if something comes up that I need to address. But I am here right now for the request to dismiss the appeal without getting into the substance of it.
Okay, so in other words, if we dismiss, it's not we deny, we dismiss.
That's correct.
The
You
motion to dismiss, I've never heard of that motion.
Okay.
Okay,
Yeah,
so,
it would be not a denial of the substance of the appeal that we would request. We're requesting that the appeal.
It's based on the timing. It didn't meet the
It's-
timing.
Correct, and so
That
it is
it's
not
n-
even properly before the board.
right. So dismiss it just out of hand because it's just, well, not out of hand, but it just is not appropriate.
That's our request.
So was the applicant informed that they didn't meet that 15-day before they made the application?
Before they,
You know,
Were they informed that they had passed the
did,
15-day
that they were
deadline?
past the 15 days?
I do not know that. I don't know if Mr. Burton does or if the applicant or her attorney would answer that. I'm not sure.
Any other
But
questions?
the ordinance is there and.
Yeah, the ordinance is clear, yeah.
I mean, yeah, as far as whether or not she knew that the 15 days had passed, I do not know.
Any other comments? Or any from legal over there?
I would just, if there are no more, just to allow the
Okay.
applicant to address
Okay,
the arguments that the planning division has made.
you hear from the applicant then?
Yes.
Good evening. So I can address this pretty quickly because it's all wrong. Pretty straightforwardly wrong. So let's start with the timing. Timing of this appeal is untimely. Now, the county's ordinance says that an appeal has to be filed within 15 days. The problem is the county's ordinances have to give way to due process. And the Utah Court of Appeals in Fox v. Park City has said the appeal period begins when the aggrieved party has actual or constructive notice that a permit has been issued. So 15 days is relevant. They have 15 days after they know or should know. And in this case, the 15 days started when my client saw her neighbor digging a hole in their yard. And that's when, wait a second, it looks like a building permit was issued. I better go down and find out. Within 15 days of that hole being dug, we filed our appeal. So the appeal is timely. There's nothing that the ordinance can do to override that fact. And the county knows that. It's frustrating that they play this game every time an appeal is filed without even trying to find out, why did you file an appeal? What was the timing? The client's here, she'll testify, she'll tell you exactly what it was, why we filed it when we filed it. We filed it as soon as we had constructive notice. So in their report, the staff
Could
said,
you give us your name and
Oh, yes.
address for that record?
my name is Zane Farrar. I'm the attorney for Angelika Spaey.
Thank
Sorry
you.
about that. So in the staff report, they indicate that they published it on Frontier as if that somehow gave kind of a notice. Well, as the Supreme Court has said, you have to have some kind of actual notice. And the court went on to say the Utah Code does not require a municipality to provide notice to neighboring landowners that a building permit has been issued. Thus, neighboring landowners do not receive actual notice of the permit's issuance. Additionally, neighboring landowners often do not receive constructive notice until construction begins. And generally, if a party does not receive actual notice of the issuance of the permit, the party receives constructive notice that a building permit has been issued when construction begins. And a party must not only have notice that a building permit has been issued, but, and here's the important thing, but must also have knowledge of the facts that form the basis of the party's objection to the permit before the appeal period begins. So the argument you just heard is without merit. It should be rejected. The appeal is timely. When my client saw the construction started, that's when she finally had notice. The planning staff has not produced any evidence that they sent her personal notice, that they mailed her any notice. And in fact, what we were told when I went on Frontier to try and find this project, I couldn't find it. I had to be sent a special link to find this project. We were told that that was because the county allowed the landowner to file it confidentially somehow. So even if it was published on Frontier, and even if that was some kind of notice, the question I would have with the county is, if it was filed confidentially, how is my client supposed to even know there's a land use permit? So the county's position is, we're going to issue a land use permit. We're not going to tell you we issue it, but then within 15 days of this issuance, your opportunity to appeal it is gone. That's literally their position. That is in direct conflict with the law. So let me next address the scope of what can be reviewed, where in their staff report, they say only the land use permit is considered a land use decision reviewable by the Board of Adjustments. So once again, going to the law, the Supreme Court, if you noticed in my prior reading, the Supreme Court was addressing a building permit. A building permit is considered a land use decision. And in fact, Weber County's building permits have been treated as land use permits in the past. Some of you may even be familiar with the case. It was a few years ago, but it was Green v. Brown. It was another case that I was actually involved in. And in that case, we were challenging a building permit. And we brought it before this body. And that eventually went into the court system. But I don't have to go to case law. I can go to the county's own ordinances. And by their own ordinance, they've eliminated this Board of Appeals from even being able to consider these building permits on the issue that we're here for today. So Weaver County Code Section 1-10-2, which does not limit the definition of land use decision to a land use permit, nor does it exclude building permits or stormwater construction activity permits. It simply means this is the definition of land use decision. A decision applying a state or county land use code to an application required by the land use code made by a person or body authorized by the land use code to make the decision. So there's a couple of elements there. One, they're applying the land use code. That's important. I want you to remember that. Two, the body that's authorized to make the decision. So those are the two operative facts that we're going to be looking at here to decide, is this a land use decision? Because if it's a land use decision, this is the board that reviews land use decisions. So section 12-2-5, powers and authority. This is powers and authority of the Board of Appeals, not this board, the other board that they're claiming has subject matter jurisdiction over this. It's just right here, plain as day in their own ordinances. The Board of Appeals shall have power and authority to hear and decide appeals of orders, decisions, and determinations made by the county building official relative to the application and interpretation of the above cited technical codes to determine the suitability of alternate materials and methods of installation and as otherwise authorized or limited in those codes. So the question is, what are those codes? Well, the codes are the International Building Code, the International Fire Code, and the Wildland Urban Interface Code. The Land Use Code is not within their jurisdiction. So if the building permit decision touches upon the land use code and the application of the land use code, this is the board. It's not the Board of Appeals, because the Board of Appeals jurisdiction is narrowly limited to building construction practices. And that makes sense, because what we're dealing with, what the Board of Appeals is dealing with is, did you use the right material? Did you put the right pipe in? Is this construction appropriate? That's what it deals with. It doesn't deal with setbacks, zoning, and other land use issues. And so the issuance of the building permit is a land use decision, but the inspections that happen underneath the building permit to make sure the construction is going along according to these technical codes, that goes to the Board of Appeals. So that's the differentiation. That's the differentiation. It should be pretty straightforward. When you read the code, it's pretty obvious. I don't know why the county's making this argument. So CLUDMA, that is the overarching statute that authorizes the county to exercise this land use authority. CLUDMA is consistent with this ordinance, county's ordinances. It states, only a decision in which a land use authority has applied a land use regulation to a particular land use application, person or parcel, may be appealed to an appeal authority. So that further shows that if it's a land use decision, it goes to the land use appeal authority. Well, we've already established that the Board of Appeals is not the land use appeal authority. The Board of Appeals has no authority over land use regulations. Instead, its authority extends and pertains to technical building codes regarding building practices and materials employed in fulfillment of a prior land use approval. The building permit. The land use code determines whether the building can be built at all. And the technical building code tells the parties what the approved building must be made of. This appeal is challenging the original land use approval, not the building materials. Conclusion, this appeal has nothing to do with any of those codes, the technical codes, and is rather not within the scope of the building official or the Board of Appeals. Rather, the issuance of the building permit that authorized the proposed construction to commence is a land use decision involving the application of the county land use code to lot 23 of the subdivision, which review falls squarely under the board. Do you have any questions?
Okay, thank you. Any questions of Mr. Carl?
Okay, thank you.
Okay, staff,
I'd like to start with the last argument that was made. County Code, again, section 12-2-3
is broad. It says any person, this is the Board of Appeals question, as to which body reviews the decision of the county building official. Any person adversely affected by any decision of the county building official must petition the Board of Appeals for a review of the decision within 30 days from the date the decision is final, period, end of quote. That's again, section 12-2-3. So our position is, as it states, any person adversely affected by any decision of the county building official goes before that other Board of Appeals. And that power and authority in 12-2-5, yes, those specific things are included among the power and authority. It does not say the Board of Appeals shall have power and authority to hear and decide appeals only of the following. That can be read as a specific enumeration of some of the powers of that Board of Appeals. But our position is it would not be limited. Our position is the general rule for appealing in 12-2-3 is what would be listed or what would be appropriate here. Any person adversely affected by any decision of the county building official goes to that other Board of Appeals.
Just a question regarding that, just because I'm a little confused about that. Is there a Board of Appeals? Oh, the county commissioners.
It's set up by the ordinance actually, and this talks about who serves on the board. Are they set up and do they function right now? I don't know the answer to that, but it is established by ordinance, and that's the way it would be.
Basically, it's not us.
It's not you.
But they basically deal with life safety issues more than zoning issues, right?
Well, the way it says, it is any person who appeals a decision
The building
by the
official.
building official goes to that.
So
board.
the issuance of a building permit was done by the building official.
Yes. And so that is what the ordinance, where the ordinance would send that appeal.
So that's basically an administrative appeal. So it's already in code. Doesn't want it that way, but so do we. We hear the same types of things. It's administrative for asking for a variance.
Correct. And the state law does allow the county to set up multiple appeal authorities for different types of.
Is the commissioners not the appeal board?
Not for this type of appeal.
Oh, who are the appeal board then?
It's set up, they appoint the Board of Appeals, and
At the time of an appeal?
I actually don't know. So it says it consists of 5 members who possess training and experience in various aspects of building construction and who are not employees of the county.
Huh.
That's in 12-2-1.
Are they active at all?
I don't know.
So in other words, that's where this should go, wherever that is,
Well, at
but
least
not here.
two of the three under this, the stormwater permit and the building permit would go to a different body than this.
A different body than the Board of Adjustment.
And that is if the timing,
The land use permit would go to us, but it was past the time, past the 15 days for the land use permit, because that was issued way before the building permit, right?
Yes.
and
And I would like to address the timing on the land use permit when you're ready. Do you have any other questions about the building permit?
No.
Staff questions. Okay, so as to the timing, counsel for the appellant raised the Fox versus Park City case, which was a case that came out in 2008, was issued by the Utah Supreme Court. It dealt with a code that did not include a specific triggering event for when the appeal period would begin. I'd like to read a little bit of that case. They decided that the section at issue in that appeal, quote, we must now determine when the appeal period begins. Section 10-9A-704 is ambiguous on this point. The plain language of the statute provides that an adversely affected party shall have 10 calendar days to appeal to an appeal authority, but, and this is crucial, does not provide the triggering event that commences the 10-day period. And they went on to say, we conclude, this is a direct quote, that section 10-9A-704 does not provide a triggering event for the 10-day appeal period. As such, we must determine what commences the appeal period. They went on to say, we join other courts in concluding that the interests of both the permit holder and the neighboring landowners are best balanced by the rule that the appeal period begins when the aggrieved party has actual or constructive knowledge of the issuance of the permit. And that is what council referred to. If they don't have actual knowledge, then their appeal period doesn't start until they have constructive knowledge. But again, that was because the statute did not provide a triggering event for the beginning of the appeal period. In contrast, our case is dealing with Weber County Code section 102-3-4, subsection A4, which says, all appeals to the Board of Adjustment shall be filed with the Planning Division not more than 15 calendar days after the date of the written decision of the Land Use Authority. That part was missing from the statute in the Fox case. Our case has a triggering event. It's the date of the written decision of the Land Use Authority. And since the code is clear, it would be improper for a court or for the Board of Adjustment to get into that balancing of interests and all those policy considerations. The courts have stated that when a statute, or in our case, an ordinance is clear, the plain language governs. And in our case, the language is plain, it is clear. The appeal period starts to run when the written decision is issued, and there are 15 calendar days to appeal. And I could quote cases that talk about that. For instance, Neilson versus Salt Lake County, one of many from the Supreme Court, where they said, we must be guided by the law as it is. When language is clear and unambiguous, it must be held to mean what it expresses, and no room is left for construction. Only when we find ambiguity in the statute's plain language need we seek guidance from the legislative history and relevant policy considerations. So those policy type considerations are not appropriate when the statute is plain. And, but even if it were, there would certainly be policy considerations in favor of an applicant who requested a building permit, because I probably shouldn't even get to that because I'm telling you shouldn't even consider that. So I'm going to stop there. And I'm going to ask you to disregard any policy arguments. But the other thing to remember is, even if the Fox case rationale applies here, and even if counsel is correct that the appeal period did not start until the appellant had actual or constructive notice of the issuance of the building permit, she did. She did have actual or constructive notice before 15 days before August 26th. And actually, that was the same outcome in the Fox case. The Fox case involved an appealing party who successfully argued that the appeal period didn't start until actual or constructive notice was received. But then the outcome of the case was that the appeal was dismissed because the court found that the appealing party did have constructive notice long before filing the appeal. In this case, if you take a look at the staff report, and I don't know if you have that in hard copy or electronic form, but if you're looking at the staff report just for this item, it's the declaration from Angelika Spaey, and it's on page 16 of 186 is what it shows on the bottom. If you're looking at an electronic copy of the if you're looking at the 226 page electronic file, it's page 52. But if you're just looking at that item alone, it's page 16 of 186. In paragraph 8 of that declaration, that page, I've got it highlighted here. Anyway, in paragraph 8 of that declaration, Ms. Spaey said, I did not hear until July 20th, 2021, that they were planning to build without HOA approval because Steve Burton had approved their plan. That appears to mean that as of at least July 20th, she was aware that this was going forward because the county had approved the plan. And so our assertion there would be that at least gives an inference of constructive notice of the issuance of the land use permit, just based on the declaration of Ms. Spaey. In addition, on July 28th, 2021, the HOA board met with the applicants to ask them not to build. And from the facts in the record, it appears that Ms. Spaey was in contact with the HOA board. So certainly no later than July 28th, there was constructive notice because people there on the HOA board knew that this was going forward. And so they met with the applicants, the Christiansens, to ask them not to build. 15 days later than July 28th would have been August 12th at the latest. So even if Fox versus Park City applies, and even if the appeal period didn't start until there was actual or constructive notice, our position would be that could have been no later than 15 days after July 20th, or maybe 15 days after July 28th. August 12th, maybe at the latest. This appeal was not filed until August 26th. And so the county's position is that was untimely and there is no way to move forward on the appeal. Thank you. Any questions?
I
Any
have-
questions?
Yeah, I have a question. In addition, and it's an HOA issue, and we don't get involved. We don't make determinations based on an HOA issue. And then also this, I was a part of the planning commission when we reestablished what timeframes for notification was. And I was very disturbed by what the county was doing before. It was, I thought, way too short a time. I believe it was 10 or 9 or something, just a short time. So I haven't seen or heard of a lot of people having a difficult time with 15 days. I was a part of that decision. So I thought it was very generous, actually, considering everybody else that's involved. 15 days can be a long time for building permits and so forth. Now, what I can't remember, so does somebody have to have a hard copy sent to them? Do they have to have notice in the mail that their neighbor is going to build?
That is not a requirement in the county ordinance.
They do have to, I mean, if there's going to be something they usually send out 500 feet and something's going to happen within 500 feet, they're going to notice of a meeting here, correct? Some cases.
There are some cases in which notice has to be sent out, yes, within a certain.
But in this case, not the county's code or responsibility anyway to notify Ms. Spaey, thank you, that her neighbor actually got a building permit.
The question was
it the county's responsibility to send out notice to Ms. Spaey that her neighbor had received a building permit?
no, there's no such requirement.
Thank goodness for that. Okay.
Any other questions? I do have, so even if it did meet the timing, the planning, I mean, the board or the determination of the planning staff had to do with whether the conditions of the conditional use permit of the PRUD were satisfied. nothing to do with with the HOA. The HOA is a private entity that the county cannot enforce. Is that true?
Civil matter.
I would respectfully like to defer that question until later because it has, in my view, nothing to do with the motion to dismiss for lack of jurisdiction. And so I would prefer not to answer that right now until after a decision has been made on whether or not that should even be considered.
Okay. And we have any,
I don't have any other questions then.
Chair, if I
Thank
may, this is Brandon. I might be jumping the gun here. You may have already been intending to do this, but we do want to give the applicant a second chance to rebut any arguments because they ultimately have the burden of proof here. So they should have the final word.
okay, thank you. Mr. Farrar, do you have anything else to add? Of course you do.
Yes.
You're an attorney.
That's how I make my money. So just to be clear, the distinction that was pointed to in Fox is irrelevant. What the court held was a party has to have actual or constructive notice. It has nothing to do with the triggering. The reason why the party in Fox lost their case wasn't because of the triggering event. It was because they watched the construction happen for many months. And then when they noticed that it looked like the building was going to be too tall many months into construction, that's when they brought their appeal. So in this case, it's quite different. 15 days is not generous. I disagree respectfully. The county and the applicant, the land use applicant, usually have months to prepare expert reports and to get surveys and to get engineering. The 15 days is merely a notice requirement where we have to submit our application, and there's nothing in the statute, there's nothing in the ordinance that says that the Board of Adjustments or the county is allowed to rush through this decision. And that's when Mr. Burton emailed me and asked me if we wanted to schedule this 2 weeks after the appeal. I pointed out, well, I haven't even had a chance to have my expert planners and engineers go up and look at it. His response was, you don't get to do that. And that's the county's attitude here, is we can do this in the dark and then you don't get to appeal it. Now, the two pieces of evidence that they cited that my client became aware that Mr. Burton had approved the plan, that's not constructive notice that a building permit had been issued. The fact that the HOA, I don't even know if this happened. Nobody is here from the HOA. I don't know that Cortland was a part of that meeting. I don't know how this is getting verified or what was discussed between the land use applicant and the HOA. My client certainly wasn't there. She didn't know what was going on with the HOA. She had left it up to the HOA. She thought they were taking care of it. She would attest. And if the board dismisses this will go to court and it will be back here, because you will be making a mistake if you grant this motion, because it is black letter law. My client gets actual notice. They don't have to mail her notice, but that could be up to the landowner. The landowner, the Fox court went on to say there are many ways a neighbor or an interested party can get constructive notice. One of them is construction. The other one is you can post a sign on your property that says, hey, this land use decision has been made. So it may not be the county's obligation to do that, but if a party gets a land use permit and then waits 6 months before anything happens, does that mean the affected property owners have no right to appeal if they had no idea it happened? If the board adopts the county's interpretation, not only will it be violating Utah Supreme Court law, it will be essentially setting up scenarios where that's exactly what can happen. That a party can get a land use permit, be working on a building permit, or be working on whatever they're doing, and months down the road, the first indications are made that a permit has been, physical indications, giving somebody constructive notice. And then only then would people around that property be aware of what's going on under the county's interpretation of their ordinance, disregarding the elements of due process. And let me quote another case. This is again the Utah Supreme Court, and this trumps the county's ordinances. Under Brigham Young v. Tremco, the due process, everyone is entitled to due process, including my client here. In fact, CLUDMA requires this board to respect the due process rights of my client. I'm just going to cite right to that statute. It's 17-27A-706. So you can't ignore this. Each appeal authority shall conduct each appeal and variance request as described by local ordinance. 2, each appeal authority shall respect the due process rights of each of the participants. Sorry. So regardless of what their ordinance says, this board cannot disregard due process rights. So the due process rights, as set forth in the Brigham Young v. Tremco, very clear. Due process features meaningful notice, an opportunity to be heard, and a process of inquiry upon the facts and the law prior to rendering a decision. None of that has been met here. None of that has been met. My client never got meaningful notice until they started digging the hole. And once they started digging the hole, my client filed her appeal within 15 days of noticing that. And my client's the only one here, I think. I mean, there may be other parties here that would testify as to when they started digging the hole. So the dismissal would basically be improper, where the county is arguing meaningful notice is not required. And I would submit, if you want to ask me questions on it, what is the county's ordinance? What meaningful notice does it ensure? Outside of the Fox holding, what meaningful notice is provided to adversely affected property owners? So, and I'd submit on that if there's any other questions.
Thank you. Any questions?
I might have one,
Go ahead.
but I've got to try to digest what you just. So can you at least address the issue that your client on July 14th was made aware, as Cortland just talked about?
But my client was aware that they were trying to get building permits. She was aware that they were in the process. Her understanding was that the applicant at the time was working with the HOA to get HOA approval of the bill. And she was not involved in that. And she was just letting the HOA carry that out. And I don't think it was the 14th. I think Portland said the 20th, but 6 days. Regardless, if she knew about it then, if there was a building permit issued then or a land use permit issued then, and she was aware of that, and somebody had told her, and somebody's here saying, I told her there was a land use permit, that's a different story. I haven't heard that. What I've heard is that on the 20th, she was told that Mr. Burton had approved their plans. I don't know what that means. I don't know if that's, okay, I've approved your plans, you can take it to the next step, because there are several steps to getting a land use permit and a building permit. So I don't know what that means. If the board is going to decide whether she had meaningful notice on something as elusive as that kind of a conversation, I would be wary about that. So does that answer your question? She did not know there was a land use permit at that time. All she had been told in an informal way was that Mr. Burton had approved the plans.
So was that a direct discussion with Mr. Burton? Do you know?
Did you?
Would you come and speak to the microphone? So the record can hear what you say.
This is Angelika Spaey.
I was told by the HOA that they had gotten approval by the county over the objections by the DRB to the size of the home and the proximity to my 1,400 square foot.
So did you call at that time when you
I
heard
have
that? Did
been
you
in
make the effort to call and
I
find
have
out if there was a permit? Did you make a call
I've been in contact with.
on the
Burton
20th?
On the 20th.
Yeah, there's a thing from your lawyer that is a declaration that says that you did not hear until the 20th that they were planning to build without an HOA approval. So you knew something was going on, and the issue is that you couldn't find it anywhere. You couldn't find out what was going on. Did you call Mr. Burton or make any attempt to call the planning office to find out what was going on?
I would have to check my records, but I was in constant contact with Mr. Burton.
Okay, so you did know then.
Pardon?
You did know, because he wouldn't have said to you, well, we'll find out. But so you did know the permit was being issued.
From the HOA.
No, from Mr. Burton. Mr. Burton made a phone
No,
call.
well, he always said to me, look on Frontier. He never told me it was issued. He said, look on Frontier. And everybody looked on Frontier in the DRB, and it was marked confidential. So we had no clue.
So did you make another phone call then? I mean, that would take about 15 minutes. Did you make another phone call then to
Well,
ask Mr. Burton? It says confidential, so I can't tell.
Basically, I'm just a regular person. I don't know.
You're a regular
process.
person that's wanting to make, that you're an applicant. You're not just a regular person, you're an applicant.
But basically, I didn't know who to call,
Oh, okay.
how to go through a process and I did what I could to seek counsel, but due to COVID,
Mhm.
people were not available. As we know, very few people are available for any of the services that we.
But you can call him and he answered the phone, so he was available.
He would tell me to look at Frontier.
Okay, and you
I have it in writing.
And you attempted to do that and it didn't work because it was so confusing. And I agree, Frontier can be confusing, but you found
It
that it
wasn't-
actually said, you actually said that it was confidential. Did you make another phone call back to say, and he was there, it wasn't COVID, he wasn't out sick, right?
Yeah, I believe that my HOA board members, and because I was still told to work with them exclusively to work.
Okay,
with
that,
them.
all right.
So I guess as a follow-up to that, Mr. Farrar, the dates,
Yes.
it does sound like maybe even in your own record that she was aware around the 20th, something to that effect.
She was aware of something, but remember, the Fox case not only says that they have constructive notice, but they need to have a meaningful, let me just read this again. They need to have, let's see here. And this is a quote: a party must not only have noticed that a building permit has been issued, but must also have knowledge of the facts that form the basis of a party's objection to the permit before the appeal period begins. So this board is faced with a tough decision. I understand that. And ultimately, whether or not the board determines that the appeal period began when the building permit was issued, or was on the 20th, or was when they started digging. I mean, those are the three choices I think the board really has, And the question it has to answer is at which one of those spots did Ms. Spaey have meaningful notice, which would include the knowledge and facts to form the basis of the party's objection. And our position is, because she didn't have the actual permits, because she didn't have that, I know it's not required, but it's not required by the ordinances, but the case law suggests that you have to have knowledge and facts sufficient to
Point out to me where in the state and what municipality sends out, it doesn't even matter, because you know that's not happening.
No, it doesn't happen. It's not the municipality's job. But that still doesn't mean that an adversely affected party does not have due process rights and they can't come and appeal it. That doesn't mean the county's done anything wrong.
And this is due process.
Yes.
And what did you say? The county didn't do anything wrong. Okay, good. I like that.
Yeah, it doesn't mean if the county doesn't send out notice, Like what Mr. Burton did saying, look on Frontier, that's not necessarily wrong. Because they don't have, you're absolutely correct. The county does not have an obligation to provide that. But that obligation is disconnected. Whether or not the county has that obligation is completely disconnected from my client's due process rights.
Well, I think that you're leaning on case law and you're so bright.
Well, thank you. You're always so kind.
You're, well, no, I am not. But I think you're spinning things.
Well, that's my job.
No,
I take the
No.
case law and I try and apply it to what I would consider is an imperfect and flawed ordinance. You'd have to admit
it's
that
not our job here to set precedents in our ordinance. It's
no,
not our job.
you're right, but it is your job to respect my client's due process.
And we're having due
Well,
process
that's what
right now.
this is. Had the
Are
planning
we
staff
talking about the
not
substance? No, we're not. We're not talking about the substance. That's the due process. This is an attempt to thwart this board from considering the due process. Now, it's a legitimate attempt. If this isn't timely, it's not a dismissal. It's a denial. It's a denial on the merits. So this is a way to avoid the merits, the substance. Is this home constructed in accordance with the ordinances? Because if it's not timely, my client has effectively waived her right to challenge that.
Well, the reason why we're not discussing the substance of the other applications, it's all one, right? It's all under BOA.
Yep.
/11, is because the other is irrelevant. If it is not timely,
I
then
agree.
There's irrelevant. So that is, I mean, I read through all your stuff. I have an immense amount of respect for you. I would never not do that. Okay. So there was due process here in my mind.
Well,
I did
and
not.
Can I just address that just for 1 sec? Go ahead. Sorry about that.
my comment is, had the county denied due process, it would not have even accepted the application beyond that 15 days.
Well,
But giving us the right to hear it gives you due process
Well,
in my mind.
actually, that's wrong. In the last time I had an appeal, the county did exactly that. They denied my appeal. The county attorney summarily said, it's too late. I appealed that to the court, and the court said, you don't get to do that, county. You have to submit it. So there's no discretion here.
So that's why we're hearing it, because of
Yes.
that court case. So
That's
good for
one of the
you.
reasons. That's
Okay.
one of the reasons.
Okay, good.
No, so let me address your point that you read through my material. We submitted 2 expert reports. One of them was submitted around October 20th. It's on Frontier. The other one was submitted as a rebuttal to the staff report. I noted that the staff didn't provide you with either of those. Now, obviously, and we would get into this with respect to their argument on the record, because they're wrong there as well. There is no record. Just flat out no record. So this is a de novo review.
Okay.
So I don't need to get into that, because if we're going to address the timeliness, I'm just going to stay focused on that. But I just wanted to address, you didn't get all of my material.
I understand that, but I understand why.
Yes.
Yeah, I understand why.
So I don't need to belabor this. I would just note that there is a balance. County is correct. There is a balance on this. And I would suggest that if the board is going to determine that it's untimely, that the board would need to specify the basis of facts as to why. Because I do think the county ordinance is flawed in light of Supreme Court holdings that it doesn't, you have to give actual notice or constructive notice. So you would have to explain, it would have to be more than, it was just 15 days beyond. Carte blanche, it's over. That's my suggestion.
And I appreciate that. I appreciate you making doors for yourself. As on the record, I understand what you're doing. Good job. For us, we are here to interpret the code and that was followed correctly.
And remember, you have to honor due process.
I feel like we are right now.
And that's fine. That's fine. Okay. If you have no other questions, I would submit, thank you, you guys.
Any other questions? Thank you. Do we have any other comments?
Yes, one correction on one of my statements earlier. I was referring to the appellant as the applicant. I misspoke there. So what I meant was that was the appellant. We do have an applicant whose attorney is present at this meeting. And if the board needs to hear from this person for relevancy,
Christensen.
yes.
I don't think.
Oh, the applicant
The
does
app-
have an interest in the outcome of this case, obviously. We would want to respect the due process of the applicant themselves.
The applicant of the building permit or the applicant of the appeal, or both?
It's the property owner, yeah, the property owner whose property will be affected by this decision. So I would suggest the board allow that person to speak. There are also maybe some adversely affected people in the area. I realize in this instance, it's difficult to determine who online might be a neighbor or might just be someone from the public. I've asked the planning staff to confirm who the neighbors are. So if anybody present that's a neighbor wishes to speak, the board can hear them as well.
So on the previous item, we didn't open it up to the public. So do we open this up to the public?
Right. In the previous item, it was the appellant was the property owner themselves, and that was it. So in this case, we have an adversely affected party appealing. It's not clear in county code, and I realize that's the reason why we always come to these type of scenarios. But to be cautious of due process, as we're trying to be today, this is the type of case where if one adversely affected party is appealing, we should hear others as well, especially the applicant themselves.
Okay, so Mrs. Christensen? Mr. Johnson?
Yes, I'm here.
Okay, we can hear you. You have
Okay.
anything you'd
I'm
like
also-
to say?
I'm also here at,
Yes, I'll refer to my attorney. I may speak a little bit later, but right now I would like to have my attorney speak.
Okay, go
thank
ahead,
you.
sir. Tell us your name and address.
Yes. My name is Lincoln Hobbs. I'm at 466 East 500 South, Salt Lake City, Utah. I do represent the property owners and the building permit holders, and I will be brief. I've had an opportunity since I am in my office to pull up the Fox versus Park City case, and I agree entirely with the county's interpretation and position of that case. The case of Fox versus Park City involved an ordinance where it said you have to appeal within 10 days. It didn't say 10 days of what. In this case, you have a statute that says you have to appeal within 15 days of the issuance of the permit. And there are two concepts in the law. There's actual knowledge and there is constructive knowledge. And constructive knowledge is the concept that a person knows or should know of an action, they have to take action. The reason you have constructive notice, and the Supreme Court specifically noted this, it's the flip side of what Mr. Forer said. If you don't have a requirement of constructive notice, you could have a developer or a contractor receive a permit, wait a reasonable period of time, start constructing, expend considerable amounts constructing, which my client actually did, and then somebody comes forth and appeals. I mean, it's the flip side, that the contractor is delayed by virtue of the lack of appeal. And I think in this case, the constructive versus actual knowledge isn't even an issue because, as has been pointed out, Ms. Spaey says in unequivocal terms that on July 20th, she heard that my clients were planning to build without HOA approval because Steve Burton had approved their plan. She knew as of July 20th, she had actual notice by her own admission as of July 20th that my clients had been approved. And Steve Burton told her that, and she acknowledges that. And if you have any questions, I'd be happy to answer them, but I think that that's the points I need to make.
Thank you. Any questions, Mr. Hobbs? Thank you. Mrs. Christensen, do you want to talk next? Chris Jansen, sorry.
I think I'm good for right now.
Nora? Yeah, we can hear you.
No, she said she's.
You don't have anything else to add? Okay, sorry.
Chair, this is Brandon. The planning staff has confirmed some of the neighbors. It looks like there may be at least one present. If the board wishes to hear them.
I would respectfully object to any neighbors commenting on this unless it directly has something to do with the timeliness issue, because otherwise it appears that that would likely be irrelevant to the question of the timeliness.
So the first determination is whether we agree that the timing was satisfied or not. If we allow further discussion, then it would open up to the public. Is that what you're saying?
I don't even know about that, but allowing neighbors to comment, it's unclear to me what the relevance would be to the question of when Ms. Spaey had actual or constructive knowledge of the decision that had been issued in this case. So I would object to neighbors testifying to unknown things.
I think we've heard sufficient. I would make a motion to. Oh, let's, yeah, you bring it to the board.
So it looks like we want to do a closed session on this as well. So we're gonna. I just want to talk about.
It's not a public meeting, it's a discussion.
Okay, we're gonna close the public comment and bring it back to the board for discussion and comment. Decision or whatever.
So I would make a motion that we close and adjourn into the conference room.
Okay, I second that then.
In favor, say aye.
If the board would cite the reason for closing the meeting for the record. Remember, Rex, you may have already done that. Just want to make sure we've got that.
Just to adjourn for discussion, for private deliberation.
We are back. Thank you for your patience. We need a motion to return to the regular meeting.
So moved.
Second.
All in favor, say aye.
Aye.
Okay, we're back.
Will the chair entertain a motion?
We have a motion ready for the, we have a motion on the table.
Chair, I,
Actually,
Not yet.
not yet, but
Not yet.
Chair, I'd make a motion on BOA 2021-11, consideration of an appeal of several permits. My motion would be as follows. The Board of Adjustment does not have the jurisdiction to look at Weber County Stormwater Construction Activity Permit or the building permit as a appeal authority. So I would move that we dismiss both of those on the fact that we do not have the authority to consider either of those. On the third one, the land use permit, which we do have authority to consider an appeal, I would move that we deny the or dismiss the appeal based upon the fact that it was in fact untimely filed by the actual statute, which would be 15 days literal, or even if we go from the point that the applicant was aware on approximately July 20th, in both cases, they did not meet the 15-day. So I would move that under both circumstances that was untimely filed and to dismiss all accounts.
A second.
Is that sufficient?
I didn't hear anything that needs to be corrected procedurally.
Okay, then I will second that motion.
All in favor, say aye.
Aye.
Motion passes unanimously.
You need a roll call again.
Yes, please, if we get a roll call on the record.
Rex,
Rex Mumford, yes.
Laura,
Yes.
Jeanette,
Yes.
all voted in favor.
Lost my agenda. Okay, next item on the agenda is to adjourn. Do we have a motion to adjourn?
So moved.
Second.
All in favor, say aye.
No.
Oh, I can't. Thank you, though. It's tempting.
It helps with my house. I get a tickle in my throat. It helps my